The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 30th, 2016 are currently trading with gold at $1,227.66 an ounce, silver $15.20 an ounce, Texas crude $38.28 a barrel, and Bitcoin is currently sitting at about 412 U.S. currency. Today in history, the year 1870, Texas becomes the last Confederate state readmitted to the Union. Though the new state constitution wasn't approved until 1876, Texas, formerly part of the Confederacy, was admitted into the Union. Today in history. In recent news, the Federal Trade Commission announced today its efforts to crack down on fake cancer charities. The Cancer Fund of America, Cancer Support Services, and their leader, James Reynolds, including Reynolds Sr., will have to surrender an undisclosed amount of their personal assets as part of the settlement with the FTC and states. These purported nonprofits agreed to be permanently dissolved and their assets liquidated. Reynolds is also prohibited for life from managing charitable assets or being part of a charity's board or a trustee. Apparently, according to the FTC, of more than $75 million the charities raised, a vast majority of these funds were going to the charities' organizers and their friends, with a measly percentage, less than 5%, going to actual patients and research. To make matters worse, an estimated 85% of the millions were spent on fundraising for the scheme itself. The charity's remaining assets will first go to pay the state's litigation fees, afterward to actual legitimate charities the state select, though an FTC spokesman did state in an email that if there's any money left, it would probably be a very small amount. After more than 6 years in development, IBM's True North brain-inspired processor will be put to the test at the Lawrence Livermore National Lab. They purchased IBM's Neuromorphic System, a brain-inspired program based on the True North chip. California Research Lab is set to use it to help the National Nuclear Security Administration battle cybersecurity issues. Consuming just 2.5 watts of power, the same as a tablet computer, the neuromorphic system can process the equivalent of 16 million neurons and 4 billion synapses, containing only 16 of these True North chips. IBM chief scientist Dharmendra Mota stated that the delivery of this advanced computing platform represents a major milestone as we enter the next era of cognitive computing. This is Rick Rohde with your lowdown for March 30th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must be cool. Bad boys, what you gonna do? Or what you gonna do when they come for you? Bad boys,
Okay, howdy. This is Randy Kelton, Deborah Stevens, Root of Law Radio, on this Thursday, the last day of March, the 31st day of March, 2016. And we are hoping to have a call in from Mary Krennick. She has some issues she wanted to discuss on the air, so there she is. I see her. She's coming up. She hasn't been screened, but I'm going to bring her up anyway. Hello, Miss Mary.
Hi, Randy.
How are you?
I'm great.
And you had some interesting stuff you wanted to discuss with us today.
I do. I was watching a little bit of the Scalia stuff and listening to Alex Jones, and the question became, should I make a criminal complaint on the coroner not executing his duty?
You're speaking to this Scalia incident?
Yes.
I think it's a good idea. This was one of the most influential people in the country. And he died supposedly of a heart attack. And I was watching one of these cop shows today, and something struck me. The guy on the cop show was a coroner. It's this movie, this program, Rosewood. And a doctor died of a heart attack, supposedly. And he looks at the scene and he says, this is not right. The guy was in bed and the sheets and covers were not moved around. And he said, when someone dies of a heart attack, they generally roll and tumble and squirm because they're in tremendous pain. And when he said that, it struck me. Scalia supposedly had a pillow partially over his head, but he was apparently laying peacefully in bed, is what they said. And they spoke to him dying of a heart attack as if the lights just somehow went out, and he didn't react or respond. And, it's one thing if I were to pass away in my sleep. But it's quite another thing when one of our Supreme Court justices, supposedly in good health, with friends, no apparent medical difficulty at the moment, in supposed good health, just all of a sudden clicks off. I think I would be very, very concerned about that. And if I were a local coroner in a Podunk county in a backwater corner of Texas, I would be extremely concerned about that. So what's the deal, Mary?
Everyone believes that he was murdered or something bad had happened involving him using drugs or partying. Everyone that I know. And so the question becomes, what was the coroner's duty? I've been told that the coroner has a specific duty to perform an autopsy if they were not severely ill in the hospital already. Outside of that, they must. I don't know if that's true or not.
Well, I would think that even if it wasn't mandatory to perform an autopsy on a 70-something-year-old person who died in his sleep, that there would certainly be some protocol or concern when the death is at the very least suspicious. Just from the reports that managed to get out, you cannot consider this anything other than suspicious.
One of Alex's reporters, Kip, said that something like because of Scalia's post, he should have had to have had an autopsy. Because of his governmental posting, that it was sort of like a threat to the government. He was, officer of the court, I guess. Was he sworn, had oaths? I mean, he had a high-ranking position.
You're talking about the coroner.
Scalia. So the fact that Scalia died under suspicious circumstances not only makes it mandatory, because I have heard that suspicious would regard anything outside of a hospital where they were already severely ill. But the fact that he had a post in the government of high priority makes this a national security concern.
Yeah, I just did a search for when must an autopsy be performed. And I'm not getting anything very definitive.
Well, I think, arguably, I could not justly tell you that if somebody over 70 supposedly dies in their sleep, they don't need an autopsy? How many kids would be killing their grandparents tomorrow?
Okay, I have here Chapter 49, Inquests Upon Dead Bodies. Autopsy, okay, go ahead for a moment. Let me find just the right statute here.
What's that?
Okay, it looks like 4910 is the statute. Autopsies and tests. At his discretion, the justice of the peace may obtain the opinion of a county health officer or physician concerning the necessity of obtaining an autopsy in order to determine or confirm the nature and cause of a death. That's not very clear.
Well, outside of this, which I will look into, and all they are saying is to confirm the nature and cause of death. It's not to try to find out if he was murdered. It's to confirm the nature. That's all. Just because there's an autopsy does not mean it has any allegation of murder.
Problem I'm seeing with the code, at his discretion, the justice of the peace may obtain the opinion of a county health officer or physician concerning the necessity of obtaining an autopsy in order to determine or confirm the nature and cause of a death. The Commissioner's Court of the county shall pay a reasonable fee, except as required by Section 264-514 Family Code, for each body that is the subject of an inquest by a justice of the peace. The justice, in the justice's discretion, shall direct a physician to perform an autopsy, certify that and no autopsy is necessary. Ah, there we go. Oh no, this is in his discretion still. It appears to be strictly at the discretion of the justice. Justice of the peace may not order a person to perform an autopsy on the body of a deceased person whose death was caused by Asiatic cholera, bubonic plague, typhus fever, or smallpox. And that's because you can't order somebody to do something that may put his life at risk. The justice of the peace shall order an autopsy performed on a body if the justice determines that an autopsy is necessary to determine or confirm the nature and cause of death. The deceased was a child younger than 6 years of age, and the health is and the death is determined under Section 264-514. Directed to do so by the district attorney, criminal district attorney, or if there is no district or criminal district attorney, the county attorney. A justice of the peace shall request a physician to perform the autopsy. The Commissioner's Court shall pay the reasonable fees. The only one that seems to apply is if the justice determines that an autopsy is necessary to determine or confirm the nature and cause of death. Now,
okay, and that's why they were interviewing the justice of the peace so much.
Wait, say that again. You say they are interviewing the justice of the peace?
That's why they were interviewing the justices of the peace so much. You know, one was out of town, another was out of town, and there was one lady on call, and she determined over phone that it wasn't necessary, I think.
When you look at something and reason and good conscience tells you something is not right, you can be pretty sure something's not right. But I don't see anything here that gives us a direct claim against the justice, other than to maintain that the justice failed to act in accordance with their oath in failing to order an autopsy to determine the cause of death. There was no doctor apparently, or if there wasn't one with the specific expertise to look at him without further examination and just say off the top of the head what caused his death. And that was another. The show today was interesting because it went to this subject. The guy was a coroner, and he was at some kind of gathering, and he gave a keynote speech. And he spoke specifically to death by heart attack, as always being suspicious, because there are a lot of things that will cause the person to die from a heart attack that's not natural. For instance, in this case, he referenced someone who was in his upper 50s, very overweight, poor health, overate on one evening, and then died of a heart attack.
Wow.
But it turned out that the heart attack wasn't the reason he died. His wife, he came home drunk, and his wife gave him something to knock him out, and then pushed cauliflower down his throat. And the restricted air passage, I don't remember how he explained it, but that, in the process of choking to death, it caused the heart attack.
Got it.
So to say that he died of a heart attack, that's not enough.
Got it.
Why did he die of that heart attack?
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, now, Mary, we could have died from running off the cliff at the end of the segment, you know. Okay. Or Deborah may take care of that for me. During the break, I did a search for murder by heart attack.
Nice.
The first one I came across. By using a radio frequency weapon, invisible personnel of surveillance station system can secretly enter people's home or office, vehicle, etc. to induce heart attack or induce cardiac arrest. The heart stopped on any unsuspecting victim to die as if by natural cause, no matter how young or how old. After the involved police of surveillance station system of the U.S. received the radio frequency weapon, their favorite death-inducing techniques are to use this weapon to either induce a target to have a heart attack or cardiac arrest, heart stopped. What's the difference between the induced heart attack and regular heart attack? Before I answer the question, it looks like this has been interpreted from something else, from a different language. Before I answer the question, we need to know what the heart attack is. According to American Medical Association Family Medical Guide, an artery is more likely to be blocked by a blood clot, a condition known as thrombosis, if atheroma has already been built up within its walls. A blood clot in a coronary artery can cut off the blood supply from part of the heart and cause a heart attack. However, before a normal person has a heart attack, he should first have the coronary artery disease. A person who has coronary artery disease will have a condition called angina, I think it's usually angina pectoris. Angina, this is a name for pain that occurs when the muscular wall of the heart becomes temporarily short of oxygen. Normally, the coronary arteries that supply blood to the heart can cope with an increased amount of oxygen, but the ability is restricted if one with coronary artery disease or high blood pressure. Angina, a feeling of pain or tightness. Angina usually occurs during physical overexertion or emotional stress. It means a person with a coronary artery disease will have pain when exercise or feeling strong emotions. There was none of this there was none of these indications with the Scalia. But then there are other kinds of heart attacks. I know I had an uncle that stood up, took 2 steps, and just fell dead from a heart attack, and there were no pre-symptoms. So we're looking for reasons to do something that will shake something loose here. The initial purpose here was to see if we could file a criminal complaint against the Justice of the Peace for official misconduct for failing to perform a duty he was required to perform. The problem is I can't find in the code, even if there was question, a specific duty on the part of the JP, other than that duty to uphold the laws of the state of Texas, protect the Constitution. If there was evidence to indicate there could have been foul play, it would seem that as the Justice of the Peace, in this case, he would have a duty, especially when an extremely high-level individual was involved. I mean, if it was a famous actor or actress, they would probably call for an autopsy. If it was a rich person, they would call for an autopsy. If it was the politician, they'd call for an autopsy. But this was a Supreme Court justice who was apparently in good health. This stinks to high heaven. And the bought and paid for press has certainly failed to make much of it. The only ones who are the alternative press, like Alex Jones.
Yeah.
So
Alex
what else do you have from the Jones reporters?
That there was a suspicious death. The reports differed. One was the lady died by suicide on train tracks. The train conductor said she was...
Wait a minute, hold on. This I'm not familiar with. The lady died by suicide. Who is this?
There was already some other type of cover-up, alleged cover-up, that some lady supposedly died by suicide at the tracks. The train conductor said no, she wasn't moving, or something. So there was concerns about that, and there was no autopsy into her death.
Oh, okay. This was a woman who supposedly was on the tracks and a train ran over her.
Right. So
now I remember this, and the train conductor said that it wasn't as if she was committing suicide because she appeared to already be dead before he hit her.
And then there was a local race going on, I believe, or going on either for a judicial position or a sheriff's position. And he was apparently telling InfoWars that this problem has occurred before there.
Okay, this problem meaning a
murder cover-up.
Unusual heart attack death or an unusual or unexplained death.
Murder cover-up. That's what I got from it. And that's basically all. And then the Trump stuff came up. Roger Stone, Trump, and that's been Trump the whole time. So, but most people seem to think it was fishy. And there was backing behind it about him not signing papers regarding coal or oil or greenhouse or, the heating situation in the world. So there were some things he wouldn't pass or something. And
well, he was a Supreme Court justice, so you could probably come up with 10,000 reasons why somebody would want to kill him because he's dealing with really high-level interests.
Yeah.
And generally, one of my sayings is that if a judge is doing a good job, generally nobody's happy with him.
Nice.
So
nice.
The idea that a lot of people could have reason to do something to him is not hard to fathom.
Okay.
This is one of those things that 20 years from now, it'll all come out. And it was exactly like we said it was, like all of these things in the past that have been coming out. But it seems like it's very easy to cover it up because when you own the press.
It's a good time to cover something up right before a freaking election.
Yeah.
How long is this election going on?
The public has other things to be interested in, so they forget very quickly. But we need some folks like you who don't forget so quickly.
Well, okay, whether I like Scalia or not isn't the point. The fact is that we have dastardly deeds going on a large scale that amount to conspiracy, perhaps on an international level. And we have local judges and police acting in concordance of this through threats or royalty as far as benefits. So when we're trying to deal with our local little village, day in and day out justice services, the same problem happens is that somebody's not following the law. Now, if this justice of the peace has full discretion, then there's nothing I can do. But if there is an error in his discretion, then I think there's a point for a criminal complaint. And whether it's taken seriously or not, remains to be seen. But it could help educate people about doing this locally.
Okay, hang on. We're about to go to break. This is Randy Kelton, Deborah Stevens, Root of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Attention air travelers. Before you book your next flight, be sure you don't get stuck in the worst seat on the plane. I'll give you a hint. It's near the back. I'm Dr. Catherine Albrecht, back with a tip from seasoned travelers after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
If you've flown lately, you know the skies can be far from friendly. There's baggage fees, jammed overhead bins, and shrinking legroom. And of course, choosing the right seat is always a challenge. But a survey of 1,000 flyers by Skyscanner, a flight comparison website, finds one seat is the absolute worst, 31E. It's a middle seat in the back, near the toilets. Of course, where there's a loser, there must be a winner, and that award goes to seat 6A. Why? Seasoned air travelers know the first few rows get to deplane first. Plus, 6A comes with a very nice window. Happy flying! I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
All increase in mental functioning.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in the hand. Won't you follow the law of the land? I don't understand. The job is to protect and serve.
Okay, we are back. Randy Carlton, Deborah Stevens, Rule of Law Radio, and we're talking to Mary in Texas. Okay, Mary, I can't see any grounds, at least not for a criminal action, unless there's something somewhat concrete. It looks like it's pretty easy for a magistrate to cover up a wrongful death.
Okay. Well, that's interesting to know.
Maybe something we may need to address in the future, because in reading this article on the break of how the CIA has developed all sorts of technologies to induce heart attacks, and it looks like their favorite is this frequency weapon.
Okay.
So anyway, the indication is that anytime there's a supposed heart attack, it should always be considered questionable.
Well, I'm trying to read some quick notes. So, under the Chapter 4910 statute, you don't see that the justice of the peace failed in his discretion?
Everything in 49 concerning inquests was at the justice of the peace's discretion, except when a prosecuting attorney requested an autopsy, then he was required to order one.
Well, could it fall? Okay. So that's why we had that little play with the justice of the peace being out of town, and then I think they had to go to the third in line for the justice of the peace.
Yeah, they probably had to get to the one they could control easiest. Okay, Mary, do you have anything else for us?
No.
Okay. I was hoping we'd find something a little more substantial.
I'll talk with a few people, and if anything comes up, I'll get back with you.
Okay, wonderful. Thank you, Mary.
Thank you for...
Okay, now we're going to go to Jeff in Mississippi. Hello, Jeff.
Hey, Randy. Thanks for having me on.
Oh, glad to have you. What have you been up to lately?
Well, I have filed a complaint, received a 12B6 in response, filed another complaint, received a renewed 12B6 in response, and I'm looking at this 12B6, and I have heard several times that a 12B6 needs to be accompanied by an affidavit. However,
yes.
When I look in 12B6 under the federal rules, I don't see that.
Well, this is, if Jeff Sedgwick is listening, he might want to call in, and I think he has spoken to this in the past. We've had a number of people speak to the requirement for a 12B6. I don't see it, because a 12B6 can be filed without actually introducing any evidence. Anytime facts are asserted, it must be verified, and in this case, it would have to be an affidavit would have to be attached, because the lawyer filing the 12B6 can't introduce evidence or can't state facts. That has to be stated by a credible witness, and it would have to be done in an affidavit form. But if they're just saying that your complaint does not meet the statutory requirements, then, and all they do is introduce law and reiterate the facts that you state, I don't understand why there would need to be an affidavit.
Oh, okay. Well, the 12B6 that I have here is pretty silly to me, and you might find it different. But the first thing that they contend is that the plaintiff's due process claim is premised on the idea of liberty interest and not property interest. Now, I've been through a bunch of case law, and that is wrong.
Okay, that is wrong. It's wrong that your complaint's based on liberty interest?
And not property interest. I mean, I've read through 3 case law, and I do fall under property interest.
Okay. So does your petition, does it state the kind of claim it is, or is it in the nature of your petition that it's a property interest that you're claiming?
I do not use the words property or liberty. I just state that my due process was violated, because I wasn't afforded a hearing. And these people are splitting words, and I've never even heard of these before these guys came up with this stuff.
Wait a minute. Okay, did they just use those words, or did they provide case law to support those terms?
There are no case law. That literally is it. It's premised on the idea of liberty interest, not a property interest. And that's it. That's their argument.
That's not a argument at all. You cannot make a proactive statement of law out of your own mouth. And that should be your response, that the 12b-6 is frivolous and filed for the purpose of delay for delay's sake.
Okay. And I've already got that typed up, a motion to strike.
Okay. And the reason I say delay for delay's sake, when a 12b-6 is filed, the time limit to file an answer is told. So the clock stops ticking when you file the 12b-6. If the 12b-6 is denied, the clock starts again. So if they haven't done their homework, they don't have time to get the answer in, they just file a garbage 12b-6.
Okay.
But if the 12b-6 is a technical legal motion, then it would have to have facts and law. You can't just have a proactive statement out of their own mouths. That's not a 12b-6. That's griping and complaining, and should definitely get a motion to strike for failure to.
Stipulates my point. It says asserts that Hill has to follow all conditions of admission requirements, and then a requirement of meeting with the Vice Chancellor of Student Affairs is unreasonable. That's what I'm saying, because he never showed any cause. An important concession that removes any doubt about the fact that the plaintiff was granted admission, albeit that he attends these meetings. And that's exactly what I said. I said they're not letting me in until they're forcing me through disciplinary action before I'm allowed in, and this basically just echoed that.
Okay, so you're saying they didn't let me in without putting me through disciplinary proceedings first, and the other side is saying we're not letting him in unless he goes. We're not denying him access. We're just putting a condition on his access.
Exactly.
So the question, there is a question before the court: are the conditions arbitrary and capricious, and or even if they're not? Does the university have the authority to put in place those restrictions?
Mm-hmm.
Have you looked at that issue?
Oh, yes, I have. And it all falls down to my right to have a hearing. Once again, Brown versus Board of Education, Board of Regents versus Roth. I mean, all of these people went through the calisthenics that they went through, but each court said that a person is allowed the due procedural rights, the rights for procedure. In other words, to go through a hearing.
You're talking about procedural due process.
Yes. And so if I did something terribly wrong, that's fine, but at least I'm afforded the right to have a hearing.
And you're saying that they put requirements in place before you could have the hearing?
Well, I never had a hearing, and they never even stated why. They just threw me out of school and then said you have to go to these disciplinary meetings, and when I wrote them back and said why, they wouldn't answer me.
Oh, okay. I misunderstood the situation. You were in school, they threw you out.
Well,
without procedural due process. Hang on, about to go to break. Randy Kelton, Rule of Law Radio, our call-in number, 512-646-1984. Give us a call. We'll be taking your calls all night. We'll be right back.
Tranquility, heavy loads of taping on scales. The time is colliding with the Crashing out on the outpost. The first kiss was so sweet. Don't have to tell me you fight for another till it's knocking you right off your feet.
Okay, we are back. Randy Kelton, Wheels Law Radio. And when we went out, we were talking to Jeff in Mississippi. And I was not up to speed on where he was. But before we go any further, we do have Mr. Jeff Sedgwick with us. Hello, Mr. Jeff.
Good evening, Mr. Randy and Mr. Jeff.
Hi there.
Okay, you had a comment, Mr. Sedgwick.
Yeah, on this liberty versus property thing. What I would like to suggest that Jeff do is Google Spokio decision, U.S. Supreme Court. Sotomayor made a comment, and I don't believe the Supreme Court has actually handed down the Spokio decision because of the death of Scalia was right in the middle of that case. But within that case, one of the comments that Sotomayor made was that a well-established right, in due process is the well-established right, does constitute an Article III violation.
Yes, and a due process violation is harm per se.
Yes.
So you don't have to go in and say...
I can't hear Jeff in Mississippi, so I don't know what his comment on that is.
Jeff, are you there?
I don't have one yet. Yeah.
So you might want to look that up to use that to reinforce and have persuasive value in your case in attempting to defeat this liberty versus property, because you are damaged per se by way of interfering with a well-established right. Hello?
Mm-hmm. Yeah. Can you hear me?
Yes.
Okay.
Okay. Because everybody in the debt industry is waiting for that Spokio decision. Because one of the things that they were claiming was, in the case of like a FDCPA, if you don't have damages in fact under Article 3, then you don't have damages. And what Sotomayor pointed out is that if they interfere with your due process with a well-established right, such as your privacy and such, you do have damages.
Well, you don't. Yeah, it's due process, so you don't have to show damage.
That's right.
Because it's damage per se.
Oh, good.
You like that, and you don't have to show intent. Okay. They did it. You like that?
On my motion to strike, do I need to?
No, you're not going to motion to strike. You're going to put in your opposition to.
Okay, I'm confused.
They put in a motion to dismiss, right?
Yes.
You don't motion to strike it. You put in your opposition to the defendant's motion to dismiss.
Yeah, you just put it in your answer.
Yes.
Oh,
you have to answer it. You don't motion to strike it.
No. Okay.
Okay. You got to get the procedures right, or you lose.
Oh.
Yeah, Judge McBride just threw out one of my suits. Because I didn't non-suit it quick enough, he dismissed it without prejudice.
In my answer, can I move to file sanctions against
you
for not having an affidavit?
No. Your answer is your answer. Motion is a separate issue. Why do you want to file a motion for sanctions?
I want to get this guy.
Frivolous motion, delay for delay's sake. They filed the Rule 12 because they didn't get their answer ready in time.
May I make a suggestion to you? Wait till you get to discovery. Then take a look at Rule 37C, because then you can file for sanctions, and you don't have to consult with them, and you don't have to get the judge's permission. You just file.
Yeah.
Tell me about 37C.
In my answer, I need to address every one of their points, right?
Yes, sir.
Okay. Rule 37C?
That's for your discovery when they start engaging in obstructionist discovery. Now, here's the thing that you might want to keep in mind. They're not going to give you any money. But what you can do is you can ask the court to sanction the opposing attorney to 100 hours of community service.
All right.
Or 100 hours of pro bono work. Or pay a sanction fee into the court, or give you your ruling the way you want it, and bust his chops. There's a number of different things you can do with sanctions. But here's the one thing you can count on. You aren't going to get any money. So forget that.
All right.
And another thing to know is lawyers are terrified of sanctions because they're afraid that the judge can arbitrarily and capriciously order any kinds of sanctions he wants to.
Like suspend his license to practice.
They're right that he can. He's not likely to, but he can, and that's enough.
Yeah. So, just keep in mind that sanctions you may want that will get you your pound of flesh without you becoming a victim of your bond like Shylock was. And Shylock, in insisting upon getting his bond, basically got a death sentence. So tread carefully. Okay. You're not familiar with Merchant of Venice, are you?
No.
I would suggest you rent that and take a look at it because your commitment for blood can get you a death sentence just like it did Shylock.
Well, I just want to win this case quickly.
Well, that's fine. That's not the same as you want to teach him a lesson.
So if I sanction this guy early, maybe I can move in and win the case.
That, sir, is fancy masquerading as fact.
Okay. All right. So no motion to strike.
Well, hello, Eddie.
Answer.
Yeah, you don't want to do that either. But when you say to the judge like in a 37C sanction, hey judge, I want you to sanction these guys for obstructionist discovery, and this is what I want. I want my motion affirmed, theirs denied, or I want Mr. Opposing Counsel over here to have to do 100 hours of community service, or I want whatever monetary sanctions you decide are appropriate to be awarded to the court.
Okay.
That way, don't ask for
you're
anything.
not coming off as Shylock.
Don't ask for anything for yourself.
No.
Let me. I've got Rule 37C. I've got an article about it, and this is how it's titled: "The Duty to Disclose Rule 37C and Self-Executing Sanction."
That's the second time I've quoted a rule to you that you found that I was accurate on.
Yeah, that is interesting.
Yeah.
Okay. My answer to their 12B6, do I want to state that they are delaying for delay's sake, or do I leave that out?
No, put that in.
No, 12B6 motion is standard operating procedure. Every time we file a complaint, the first thing that's filed in is not an answer. It's a motion to dismiss 12B6 or 12B1. You're not going to get anywhere trying to get sanctions on 12B6. Give it up.
Okay.
But at least ask the judge to deny it because it's frivolous. If they're going to file a 12B6, at least they could do is do their homework and put some case law in it instead of just griping, claim it to be frivolous and delay for delay's sake.
No. Change it. Okay? In the absent case law, counsel has put forth fancy masquerading as fact.
It's a nice turn of phrase.
Okay. Do
you know what that means?
Affidavit.
Not required for 12B6.
Not required. That's what I wanted to know. Okay, good.
Well, why?
Well, I was going to chase that rabbit.
No. Why would it not be required?
I have no idea.
Because they're asking for a ruling on the rules.
Okay.
So what are they going to swear to? The rules are the rules?
I got you. Okay.
Well, and we addressed that earlier. They're normally in a 12B6. They're not producing evidence.
Not stating. They're trying to state facts.
They want to chant down Babylon and burn down the whole nation. But them operate the land wrong. I'm going to say Republican and them a scratch man. Tell them I'm a libertarian. Them say we want to lose, but we want to win. Come round. Justice and peace. Child of rule is time. How are we say? Chat for hours.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio. And we have a very special guest, Mr. Jeff Sedgwick, with us, and we're talking to Mr. Jeff from Mississippi. Okay, Jeff, we're clear that no affidavit is required on a 12B6.
No, on this 12B6. This motion for 12B6.
Yeah. Generally, an affidavit is only required when a litigant is introducing facts or evidence into the court, and the pleading that it's in needs to be verified, and it can either be in the pleading or as a separate affidavit. But this stuff I've been hearing about a 12B6 requiring an affidavit, I never understood it. And Jeff has kind of handled that for me. This time he didn't find me wrong. That's a nice change of pace.
I'll get you later.
I know.
They're not still young.
Well, he may be.
Oh wait! When Deborah said that you were going to be producing
she said
the show,
do a show with you or over you, whichever one it took.
And I had a condition that you only say nice things about me.
Oh, are you making a presumption that all of my assertions deal with you specifically in person?
Well, Deborah thought that was pretty hilarious.
Yeah, that
She
sounds like
said,
one of those
good luck
guilty
on
dog
that.
things. That sounds like one of those guilty dog things, doesn't it, Jeff?
Oh, jeez. Yeah.
Okay, Jeff, Mississippi, do you have anything? Is all your questions answered?
Yes, I will crank out that answer and get it filed by Monday.
All right. Now, here's the thing to look for. If they make a statement and there's no case law, it's definitely conclusory and probably even speculation.
Okay.
And as I pointed out, what are they going to affidavit? Their speculation? The rules? I don't think so. Now, there might be something else in there that I haven't heard as yet that might be a statement of fact or evidence. I haven't heard it yet. But, you may want to address that, all of their points. Bringing it to the attention of there's no authority for the statements they made. They're conclusory.
Right.
Or speculation, as the case may be.
Yeah, that's what I was going to say. They made proactive statements of law out of their own mouth. They put no law or facts before the court, so the court has nothing to consider.
Okay, got it.
Okay.
All right. Well, that does it for me. I'll talk to you.
And one other word. Relax on the sanctions, please and thank you.
Okay, you bet. You bet.
There's the old saw of revenge is best served cold.
Mm-hmm.
I thought that was
Keep
serious.
that in mind.
Well, I'm just trying to make a tackle. That's all I'm doing.
Well, if you win the case, their face is going to be in the mud, isn't it?
Yeah.
What more do you need?
Yeah. Okay. Well, I'll get that answer out, and I'll talk to you guys next week.
All right.
Thank you, Jeff.
Thanks a lot.
Okay, now we had Pat in Houston who had a question about how to keep the police from following you around. Pat, if you're still listening, call back in. We'll take you right away. I did want to get to that. And every time I find a police officer following me, I pull over almost immediately. I have pulled over, got out, and walked out in the street and flagged the cop down to ask him why he was following me. This was years ago. I won't go into that whole story, but if you think a policeman's following you, just pull over. You pull over, you get out. Then if he stops, then he didn't stop you, you stopped him. And it puts him in a difficult position, and it'll get him off your bumper in any case. And if he gives you any kind of a hard time, call 911 quickly and get another officer out and ask the other officer to arrest the first officer. Then you get to watch them both do this little chicken dance, and it makes them want to go somewhere else. Okay, now we're going to go to Charles in Georgia. Hello, Charles.
How's it going today, Randy?
It's going well. How are things with you?
If the laugh could tell a story. Well,
Okay, bring everybody kind of up to speed.
Okay, this is a call about family court.
Okay, hold on, Charles. Back the mic a little bit away from your mouth. The mic's distorting a bit.
Okay.
Put it kind of down under your chin a little bit.
Okay, is this any better for us?
That's much better.
Okay, this is I'm calling about family court. I had a child support order entered against me for a child that was born 5 years ago, of which I knew nothing of. And now all of a sudden the mother wants to come after me for the child support, and still to this day has not contacted me. And my phone number has been the same number for 10 years. So, I've been doing this thing since August now, and they've entered an order against me to pay, somewhere in the neighborhood of like $400 a month, when I only make $8,000 a year net income. So, they sent me these orders from Michigan, and I read this. So what I've done is I've crossed out everything but one sentence in the 10-page 10 pages of orders that they wanted me to sign, and I signed it at the bottom. I went and got a notary, and I mailed it back to them. Yesterday. Now, I'm curious to know what's going to happen. I want to see if they're just going to just ignore what I've done, or if they're going to do a chicken dance, or what they're going to do and send me some more papers back. But
well, how did they maintain jurisdiction over you?
In the papers that I sent, I sent you some papers. Actually, I know you probably haven't had time to look at them, but I sent you the actual orders. It said this court has jurisdiction over this case and over me. Now, I'm not sure how this particular court can come up with the idea that they have their jurisdiction over me. I thought that has to come from somewhere else, but they maintain that they do.
Have you filed a challenge to subject matter jurisdiction?
I haven't filed anything other than a notice of removal from that court, and they have not removed it to the federal court, and they never did.
Then you might want to file a petition for I want to say writ of mandamus, but that may not be the right term. It raises a question: can you remove a family law issue to a federal court? I would think so. I wouldn't, but there could possibly be a specific restriction. Did they respond to your notice of removal?
Their response was, "Where is my case law?" And I didn't respond to that. I just said, "Remove the damn." Excuse me, language. I just said, "Remove the case to the federal district court," and they never did. And the very next thing I got was the order. No, I'm sorry, not the order, but the very next thing I got was a.
Oh, okay. Hold on. When you filed the notice of removal, you gave no. Did you file the notice of removal with the federal court as well?
Yes, I did.
Okay. Now you can go to the federal court. See, the federal court has jurisdiction, period. Now you file with them a challenge subject matter jurisdiction. I have one of the seminal cases on this is a guy in South Carolina, black guy, goes into a white bar, gets into a fight with white guy, knocks out the white guy hits his head, dies. Prosecute the black guy for murder. And they pick the jury, they get ready for trial, and he files a notice of removal. Well, the trial court's annoyed, and they already got the jury, so they go on with the trial. The federal court gets the removal and immediately remands it back. They threw out the conviction saying that once the case was removed, the state could do nothing until there was a remand. It didn't make any difference if there were no grounds for removal. Once you don't request a removal. When you give them notice, it is removed. So you might file a complaint sue the judge himself. He has no subject matter jurisdiction. He has no immunity. So file suit against the judge and the lawyer on the other side for malpractice. And then petition the district court for sanctions and an order from the district court ordering them to remove the case. The federal district court. Federal court probably doesn't know what's going on because they're busy with other stuff. So you have to give them notice. And the chances are is the federal court's going to smack them good. The federal courts don't like the state stepping on their jurisdiction. They're just figuring you don't know what to do. But what you may have done is given them time to screw up really good. Because you got this order and it scared the bejesus out of you. You're terrified. You're having to go to a psychiatrist for counseling. You're so afraid. You're worried every time the doorbell rings that there's going to be a bunch of cops with scars on their knuckles dragging you back to Michigan.
Right.
You've got post-traumatic stress syndrome. This is horrible. They're denying you in procedural due process. This is, when Jeff said you have to be careful because you can lose this thing on procedure. This is procedural. It has nothing to do with merits. It is procedure. When you file a removal, it is removed, period. Hang on, about to go to break. Randy Kelton, Real Our Radio, our call-in number 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now.
Okay, we are back. Randy Kelton, Real Radio, and we're talking to Charles in Georgia. And we do have Eddie Craig here in the background, and we're going to bring him up in a minute. But this time he's coming on my show, so he can't say anything disparaging about me. That's a new rule I just made it up.
I've said this before, and I've never made it direct, but here we go. I never, ever make fun of Randy. Never. I've never done that. Mother Nature beat me to it.
Well, thank you. That's really nice of you. Okay. Charles, I think you're in a catbird seat. And, we had someone recently, a good friend of ours, lose a 6-year case over a procedural error. And this is strictly procedure, nothing personal. But procedurally, the clerk had a duty to remove this to the federal. So sue the clerk, sue the judge, and sue the lawyer on the other side. Just for yucks. There's a good chance, and then file a motion to the federal court for an order to order them to remove it to the federal court. Because procedurally, like rescission, in the Jazanowski case recently on rescission, the court said when a notice of rescission is filed, rescission is accomplished. Even the filer cannot reverse it. It's a done deal. When you file a notice of removal, removal is accomplished. You can't unremove it. Only the judge can unremove it, the federal judge. And in my experience, that federal judges like to flex their muscles on state judges, especially when they defy the Fed. So, make you up a suit against them, make you up a motion to the court that it was removed to, and give them notice. You filed a removal and they ignored it, and they subsequently filed an order that was arbitrary and capricious. And when they lacked subject matter jurisdiction, and ask for tell the judge what they did, and see how he thinks about it. And you might do a search for removal and find some case law like this one out of South Carolina, where it was strictly procedural. This guy they got him dead bang. I mean, he was guilty. But they threw it out anyway, just because the state court violated procedural due process.
So if that's the case, I should definitely hurry up and file the subject matter jurisdiction motion as well.
I'm thinking you make the subject matter jurisdiction claim in the form of a civil suit against the judge. That'll jerk a knot in his drawers. There's nothing for him to, the case is not in his court anymore. So filing a challenge to subject matter jurisdiction in that court would kind of be a waste of time because they can't even hear it.
Yeah, there's nothing they could do at all once that removal was filed. They don't even get to go put it in the mail because it's not up to them. It's done.
Yeah. There's one thing the judge can do. He can order the clerk to send that stuff to the federal judge, or he can dismiss the case. If you're the defendant, he can dismiss the case. He can do administrative things, or he can dismiss for whatever reason. If the court, if it's frivolous or something, he can dismiss the petition. That ends your problem. Or he can do those administrative things that need to be done that have nothing to do with adjudication, but he can't issue any kind of order concerning adjudication of the case, because now he's stepping on a federal judge's toes. You got a shot at him. And bushwhack is great fun. By filing a suit against the judge, you make your subject matter jurisdiction allegation in your lawsuit. That'll adjust his attitude.
I see.
And you got to know these state judges are terrified of federal judges. Everybody's terrified of federal judges. So, okay. Put it together. If you want me to look at it, send it to me. And you put on there, I'm suing a judge. I will definitely make time for it.
Okay, because I was, my mind was to sue the judge, the prosecutor, the claimant, or the plaintiff, and this friend of the court for defrauding me, or for shielding the property. That's what we kind of discussed there a while back. So this is a little bit different. This is a little bit different take.
Yeah, don't overdo it. Don't you need to sue everybody here? Stay strictly with, you remove the case, the judge, and I would only sue the judge, the clerk, and the prosecutor. I mean, the opposing counsel. The client didn't understand this. And a jury is going to say, well, you can't really blame the client for what the stupid lawyer did. So you sue the lawyer. And let the lawyer claim, oh, you can't sue me, you got to sue my client. We see how that works for him. But just the judge and the lawyer, because this is so technically procedural, they absolutely knew what they were doing was wrongful.
Okay, so what I'm going to do, I'm going to get everything that I have on the record. I guess I have to have them send it to me because everything is in Michigan, and they're not.
Do you know someone in Michigan who can walk down to the court and get the record?
Yes.
Have that done. Your person who goes down there, have them wear a nice suit. And when they ask who they are, you tell them, that's not your business. I'm just here doing some research. Pretend like you're someone important. When you don't tell them who you are, it makes them crazy. They're not allowed to ask. You're exercising a right. They can't ask you anything. So the less he tells them, the better. Tell them exactly what he wants, and if they give him any kind of guff, tell him, just go get my records. I don't need your legal advice. And if they say anything to him that he can in any way construe as threatening, wonderful, then you get to file against him for obstruction of justice. Okay, this is Thursday. We're a little short of time. I have a couple more callers. I have one in particular I want to get to. Do you have anything else for us, Charles?
No, I just wanted to say real quick, my last time I did that, they made the person I asked to go in there and get it, they made him have ID and put his phone number on a piece of paper, and they put that into the record.
Okay, ask each person, have him ask each person he talks to for their state-issued ID. I will send send me an email, I'll send you a contact sheet.
Okay.
And he takes out the contact sheet, and every time he speaks to somebody, he asks their name, can I see your state-issued ID? And writes down who they are. And they see this structured contact sheet, now they're worried about who they're dealing with. And if they insist in order to give him the records, go ahead and give it to him, and then he can file a complaint against them later. But make it as, your guy needs to understand he is exercising his right. And you want to make it so that they worry about who you got coming down there. Okay, we're about to go to break, and we're running out of time. Call back tomorrow night. We'll have more time. This sounds like a lot of fun.
All right, thank you very much.
Okay, Randy Kelton, Rule of Law Radio. Call-in number 512-646-1984. Pat, we'll pick you up on the other side. We'll be right back.
The Chicago Marathon is no tiptoe through the tulips, but a pregnant woman overdue with her second child ran the whole race before going into labor. I'm Dr. Catherine Albrecht, back with the amazing story of the Marathon Mom next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Amber Miller, a 27-year-old mom from suburban Chicago, gives new meaning to the word endurance. Miller was pregnant and 3 weeks overdue at the start of the city's marathon. She'd run 7 times before, including once while pregnant with her first child, so she figured, what the heck, and planned to run only half the course. But when she got started, she just kept going, finishing the entire 26 miles in just over 6 hours. Then at the finish line, she had a more urgent race to run to the hospital, where she gave birth to a healthy 7-pound baby girl. Phew, I bet that was a relief. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Say.org.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free Tolly? Who you want to chip? Me no free Tolly. You can't chip me. All I'm saying. Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And anyway, you go computer ready. You can't hide me say from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the granny, chip in me, chip in your baby, chip in your...
Okay, we are back. Randy Kelp on Groove Radio here with Mr. Eddie Craig, and we're going to Pat in Texas. Hello, Pat. I hear you have the police following you around.
You know, I didn't think I sounded like Pat. Hi, Randy. Hi, Eddie.
Hi, how are you?
Okay. Went to court today. You know, I got to watch what was going on. And got a question. We have an attorney that, after being paid several $1,000s for, we contracted with him back in June. The only thing outside of one extension that he has filed is to withdraw. He has not filed any motion in my husband's case.
Oh, wait a minute. Is this a criminal or civil?
This is criminal.
This is Pat.
Okay.
Over, you know Pat.
Wait a minute, Pat from South Texas? Oh, you're not Pat in Houston.
This is Meta.
Oh, it's Meta. Okay, we had a Pat from Houston who had the cops following him around. I thought that was you. Oh, okay.
No. Pat was the one where he was doing 60 miles an hour, had cruise control set at 60 miles an hour, going down Ranch Road 395. Excuse me, 349. And VPS officer passes him by, pulls over to the side of the road. You know, it looks like he's on the phone or something. Turns around and starts following Pat and tries to get Pat to pull over. Pat signals to him by waving, and the cop even admits in his paperwork. He had 2 sworn affidavits. He did an original one, and then he did a second one without notifying anybody that was going to be it was a second copy, a revised copy, a change. But they arrested Pat, claiming he was
evading arrest.
Evading arrest with a vehicle. Although Pat signaled to him, and the public service announcement said, "Let the cop know that you're there, and then go to the next nearest safe place." Which, of course, on Ranch Road 349, it's between Sheffield and Dryden. There is absolutely nothing. And on the tape recording from the DPS officer, they asked why he didn't stop. He said, "I was going to a safe place. I was going to the Dryden Trading Post." Well, they found on him claiming he was trying to avoid arrest, although there's no warrants out on him, no tickets, not even a speeding ticket on record. But again, we have filed against the judge and the DA, and we filed against the county sheriff and everybody for different things over the years. Nothing ever came of them because they cover everything up. But and the guy that was on the grand jury that indicted Pat, Pat has a sworn affidavit that he was trying to get filed previously against this guy and then other members of the water board. They were on the conservation, so he already knew that Pat was trying to file criminal charges against him. So there is he hated Pat. But that was not the issue. Today we went to court. The last time we went to court, which was the first time, was end of January, and the lawyer sent Pat an email back and forth. Pat was the one who initiated about what was being accomplished, because when Pat went to visit him and to check the information that he got from the from the DA's office and stuff. He wouldn't let Pat look at it. Instead, he called him in his office, had a friend who was a former police officer who's now teaching college, and he basically interrogated Pat. And then when Pat got done, he wanted to go check the evidence and stuff that they had, and they said, no, it's too late today. And Pat made the trip to San Antonio strictly to look at the evidence and see what they had, motions and things.
Okay, wait a minute.
After that,
this is your lawyer?
Yes, Pat's lawyer.
Okay, this is what lawyers do, especially if they're criminal defense lawyers. They feed you a line of crapola in order to get the original retainer. And then they dance around with horse manure filings and pretend actions until they use up the retainer.
Oh, no. The day before the first court hearing, he wrote Pat, and one of his replies was, maybe I'm not the lawyer for you. And both Pat and I agreed he's looking for a reason to get out. The next day, he comes into court a half hour late. He was sitting out in the parking lot. He claimed he thought that he was supposed to show up at 1:30. He had the documents. He had the file. Oh. He knew when time. He just wanted to make a grand entrance. And then Pat asked him if we want to talk before, and he said, no, I'll talk to you after I talk to the DA and the judge. So Pat had no idea what he was doing, nothing. When we were outside, when it was over, we went outside, and I caught up with him first as he was going out the courtroom. I asked him, are you going to file a motion for an evidence hearing? Hallie Bard, who worked for him, she's back in Louisiana, she was the attorney originally on the case, and she told Pat that she had gotten a letter from the Attorney General's office, and so did Gallegos, who was the U.S. Assistant DA in Del Rio. And they both got letters from the Attorney General's office saying that all that public information request we had from the sheriff's office, the sheriff claimed that he gave to the DA's office. Well, Gallegos said, no, he didn't give it to us. We don't have it. And so that's why Hallie was going to do an evidence hearing, but she filed no motions either.
Okay, hold on. Has your lawyer filed a motion to withdraw?
Yes, and that was what we went to court today for. And what he's using for the reason was...
Wait a minute. Did you object to the motion to withdraw?
Oh, yes.
Good. Have you bar grieved him?
Not yet.
Do so. Do so immediately.
Oh, no, you have to hear this one. When we were at the court last time and we went outside, I asked him several questions. I asked him, was he going to do an evidence hearing? Was he going to file a due process violation because the deputy, Benacomo, lied saying that Pat said he was not going to stop, that he was going home. Yet the tape recording from the DPS officer specifically said, you can hear Pat say, I was going to a safe place. I was going to the Dryden Trading Post. I also asked him if he was going to do a motion to see what was presented to the grand jury. Because Pat, during that stop...
Wait a minute, Meta. We're going to run out of show here. We don't have time for all of the details.
Okay.
At the end of the day, what's the end result here?
I had a tape recorder. It played when I was talking with him, and he says that I was tape recording him, and that's why he wants to withdraw, because he can't trust us. And the judge today in court says we are not allowed to tape record in court unless he gives us permission.
Okay, great. That gives you a claim against the judge, because we have federal case law that says you can record your public officials in the performance of their duty. Your lawyer mainly. Okay, when you go into court, it's like you're sitting at a four-sided chessboard. To your right is your lawyer. To your left is opposing counsel. Across from you is the judge. You have a relationship with your lawyer. Your lawyer has a relationship with opposing counsel, in this case prosecutor. Both of them has a relationship with the judge. You're the odd one out. So if you're going to win your case, you got to get some politics going. And in a criminal case, the best way to do it is to kick your lawyer right square in his professional behind. Bar grieve the crap out of him, and when he files a motion to withdraw, object to the withdrawal, because the judge can't let him withdraw unless you agree to it. And then let your lawyer know, you're not throwing me under the bus.
Oh, no.
I will grieve you every time you spit. So, now what happened? Wait a minute. What happened? Wait a minute, madam. Listen, this is politics. It's not law. Okay. You're not going to win it on the facts and the law. You're not going to win on the facts and the law, and that's all there is to that. Okay. You can keep fighting them. That's not how you're going to win. If you can force this lawyer to go to the judge and the prosecutor and say, This client is kicking my behind. You got to bail me out here. That's the only way. Hang on, Randy Kelton, Rules by Radio.
Okay.
We don't have time for it. We're going to the last segment, so we'll give the call-in number. We'll be right back.
Okay.
Hello? Oh, man, in jail? You got busted, man? Oh, man, I'm broke, dude. Some things in this world I'll never understand. Some things I realize fully.
Okay, we are back. Randy Kelton, Wheels Law Radio, and we're talking to Pat in Texas. And Pat, I didn't mean to cut you off there, but you're in a good position.
Okay.
In order, the last case I won in Austin, they dismissed the case specifically to protect my lawyer from me. Otherwise, they would have stayed after me forever. But all of these guys are connected. Your lawyer's only job is to make sure you don't have any grounds for appeal. If he doesn't do that, that judge and that prosecutor will screw his next client and the next one and the next one to get back at him. So he is not going to work in your benefit unless he has plausible deniability.
No, he's.
And you need to.
I'm more inclined to think someone got to him because when we first got to him, or Pat first went to him, he agreed that what they did was wrong. He supported Pat. Then all of a sudden,
Hold on a minute. I know this story. That's what I was telling you about what they do. When you first go to a lawyer, oh yeah, those dirty rotten rascals. We can do this, we can do that. He's trying to get that retainer. Once he gets that retainer, now he's got your money. That's when he sits back and lets things take their course because he knows you're going to feel this pressure constantly building up on you. And then if you're real easy, then he's going to hit you for more money. He's going to throw you out of the bus anyway. If you're difficult, he wants to withdraw. But you were smart enough not to let him just withdraw. Now you got your lawyer. What you need to do tomorrow morning is bar grieve your lawyer. When you bar grieve your lawyer, he is going to have a conniption. But he can't say anything to you about it because if he does, you bar grieve him for that. And now he's going to, the only place he can go for salvation is to run to the judge and the prosecutor and say, this guy is kicking my behind. You got to help me out here. Use your lawyer to use his political influence with the judge and the prosecutor to get you out of this. You're just one case. That lawyer's going to be back with a lot more cases, a lot more people he can screw. And go ahead.
I don't think this is the case on that one. And as I was saying, he's not from this area. He is from San Antonio, so he doesn't. Austin, so he doesn't. Jamie Bellagio does not come down to Dryden normally, although he claimed he used to hunt out here. But I have a feeling someone got to him because after that interview where his friend, who is a cop, came in and basically interrogated Pat without asking Pat if it was all right for this guy to be in there or anything, his attitude changed, and it went from you have a right to go to a safe place to all of a sudden, cops don't need to be putting up with people just taking off and not stopping in the middle of no place where there's nothing. And, we have two deputies out here that have reputations of beating people up.
Okay.
So.
What is your question? Where are you at now, and what do you want to do?
Well, one, I do want to make a claim against we do want to make a claim against the judge, but we also want to do something. I don't think the bar grievance is going to do anything because we bar grieved people in the past and nothing ever came of it, and I do mean nothing. And no, they don't report it to insurance companies. They just blow everybody off.
Pat, it always gets reported to the insurance company. If the lawyer doesn't report it to the insurance company, he's not insured. And the last thing they're going to do is come to you and say, when you filed that bar grievance against me, you really kicked my behind. They are going to do everything they can to make you think it has no effect. But I assure you it has major effect. They threw out my last case against me because I told my lawyer, if you fail to adequately adjudicate one issue, I'll bar grieve you for that. It's his first year in practice. They would have canceled his malpractice insurance immediately. We stood in the courtroom. I'm outside the bar. He's up at the bench talking to the judge and prosecutor. Came back to me and told me that the prosecutor said that she knows who you are, and if you start filing criminal complaints, she's going to charge you with tampering with the government document. I looked over at the prosecutor and I said, she said that, huh? He said, yes, she did. I reached in my case, pulled out about 30. I said, here, I've got 30 complaints against these officers. Here, tell her to get over here. I want her to verify these in accordance with her duty under Article 2.06. And I pointed at the prosecutor. You, get over here. She kind of backed up against the bench. I handed them to my lawyer, held up both hands with his palms out. I'm not taking them. I'm not taking them. Take them, you chicken. Well, the judge called a recess. We went out. Before I could get back, they called me to dismiss the case. They dismissed the case to protect my lawyer from me because he had an unruly client, somebody that he couldn't screw around and throw under the bus, somebody who was willing to even go after his own lawyer if he didn't do his job. We just had someone in a bankruptcy case. The lawyer tried to walk away, and she objected to it. And the lawyer just whined and cried, and the judge said sorry. She bar grieved him 2 or 3 times. All of a sudden, she gets a good ruling in the bankruptcy case. You have to fight these guys. Take the fight back to them.
Okay.
They didn't get to this lawyer. This is what all of them do. I hear this same story over and over and over. Same thing. They feed you full of a bunch of crap. They get your money, then they start screwing you around. And when you start hammering back on them, when you file a bar agreement, they're not going to tell you. The last thing that lawyer wants is for you to understand how much you hurt him. Like Ken Magnuson, he filed early on when I first met him, I had him file a bar grievance in a case. 4 years later, he was being an election judge, and the lawyer that he filed the grievance against was being considered for a partnership in this law firm, and the head of the law firm was another election judge. Kid and them got to talking, found out they knew about each other. And he told this lawyer about filing that bar grievance against this guy. And he said it didn't have any effect. He said the guy leaned across the table and said, Mr. Magnuson, you hurt him far worse than you can imagine. Bar grievances work. And if you step right in the middle of your lawyer, he don't have to be your buddy. He's under contract. You don't care if he likes it or not. He either does what he's supposed to do, or if you've grieved him and then you file a malpractice suit against him, they'll almost certainly cancel his malpractice insurance. And everybody knows about it. Well, the first place he's going to go is to the judge and ask the judge to get this client off my behind. He's going to ruin my career. Help me out. All politics. Pat, would you call in tomorrow night? We have more time.
Okay.
I would like to go through this in somewhat more detail.
Okay, then. I'll talk to you tomorrow.
Okay, this is what we do. I want your hubby off of this. I want him to be able to kick their behinds, and I'll do everything I can to help you.
Okay.
Thank you.
Tomorrow. Bye.
It's nice hearing from you. It's been too long.
All right.
Okay. Bye-bye, Pat. Okay, now we're going to go to Gary in Oklahoma. Hello, Gary. Hello, Gary. What do you have for us today?
Are you there?
We are here.
Okay. Yes, I've been out of work and I've had a hardship, and my property tax.
Okay, hold on, Gary. Move the speaker down, just down by your chin, just out of the front of your voice, because the air is distorting the mic.
Okay, is this better?
Much better.
Okay. I received my home, and it's fully paid for, and I just got a property tax notice that they're going to sell it in the sale. I had a back injury and have not been able to attain any kind of employment since. And so...
Okay, hold on. Property's paid for. What percentage of taxes relative to the value of the home is owed? Like 50%, 30%?
I believe it. What do you mean, for each year?
No, total amount they're claiming.
$10,000.
How much is the property worth?
Last time I saw the assessment, it was $193, but
okay.
It is a trust, and it's held at $134.
Okay, so they're claiming they're going to sell it for $10,000, and it's valued at 20 times that amount almost.
Right.
Have you talked to them about a payment plan?
They said by law I have to pay it in full.
That's not true. As far as I know, that's not true in any state. Eddie, do you have any knowledge about that?
No, I don't.
Okay, call us back tomorrow night. I'll do a little research on Oklahoma property tax law. But there's a good chance they're lying to you. We are out of time, and I'm sorry taking so much time. But call us back tomorrow night. We have a 4-hour show, and I'll do a little looking on that. That's just outrageous, taking a property for 1/20th of its value.
Yeah.
Okay, thank you for calling. This is Randy Kelton, Blue Law Radio, here with Eddie Craig, who just spent too much time on the air and never gets off the mic. You know how Eddie is. Thank you all for listening. Good night.